When an individual makes a will, they do so in an effort to make sure that their property is distributed at their death based on their actual intent, instead of the presumed intent that is used in intestacy. But because a will doesn't actually take effect until after the person dies, the probate court is unable to ask that person to verify that the will that they have in front of them is indeed theirs or is authentic. They also can't question the individual to make sure that the will was made voluntarily and that it wasn't coerced. And finally, the court can't ask the decedent to clarify the meaning of the will. This chapter addresses concerns of authenticity. The two following chapters on contests and on construction will address the voluntariness of a will and discuss the meaning or interpretation of the will. So again, in this chapter, we're focusing on authenticity. I'm going to give you a quick chapter overview. Section A of this chapter is on the execution of wills. This is also referred to as testamentary formalities. And that is what this video is going to focus on. We're going to talk about the difference between an attested will versus a notarized will versus a holographic will. We're going to consider the debate between the ideas of strict compliance versus substantial compliance versus the harmless error rule. And we're also going to look to see whether extrinsic evidence should be allowed to establish the testamentary intent. In the next video, we'll discuss Section B. In that video, we'll cover the revocation of wills. More specifically, it'll look at the formalities that are needed to revoke a will. Section C, we will be discussing the components of wills. This section will provide us with some technical doctrines that we can use to give testamentary effects to documents that don't quite meet the testamentary formalities or can't stand on their own. Finally, there's Section D, which is on contracts to make or not revoke a will. So Section A is in the first video, Section B is in the second video, and Section C and D are in the third video. A quick note on terms. Throughout this video, I'll be referring to a decedent that has made a will as the testator, and the persons who receive gifts under the will as beneficiaries. So let's begin with Section A on the execution of wills. For an attested will, there are three requirements. An attested will must be in writing, it must be signed by the testator, and it must be accompanied by an attestation. For the purposes of this course, we're going to focus on two statutes or model statutes that define what is necessary for proper attestation. And those two are the English Wills Act of 1837, and the second is the UPC, the 2008 revision. All right, we're going to compare these two acts. So both the UPC and the Wills Act require that the will be in writing. And they both require that the testator sign the will or that someone signs the will on the testator's behalf at their direction and in their presence. So either the testator needs to sign or someone signs the will on behalf of the testator at the testator's direction and while the testator is in their presence. Now, the UPC allows for conscious presence, and we'll talk a little bit later about what that is. Next, both the UPC and the Wills Act require two witnesses. So I'm just going to put this over here like this so I don't have to rewrite it. So both also require two witnesses. And these two witnesses need to sign the will. However, the UPC allows for a notary republic to take the place of these two witnesses. The Wills Act does not. The UPC also differs from the Wills Act in two other respects. The first is that it does not require that the witnesses be present at the same time, whereas the Wills Act does require the witnesses be present at the same time. So they both have to be present at the same time and sign at the same time. You can see that here. The other difference is that the UPC does not require that the witnesses sign immediately after witnessing the testator's signature. They only have to sign within a reasonable amount of time of witnessing the testator's signature. So the Wills Act requires not only that the two witnesses be present at the same time, but that they sign directly after the testator acknowledges that that is their will or has signed it. So again, go ahead and summarize the differences between the UPC 2008 version on the execution of wills and the English Wills Act. As you can tell, the rules that govern whether a will was validly executed, they're pretty specific. And despite their specificity, there are still some issues that commonly arise in their application. And in determining how much leniency the court should give in looking to see if these formalities have been followed, the court applies one of three different rules depending on the jurisdiction. So where all of the formalities have not been met, a court can still find that the will is valid, but that depends on which of these three doctrines that the court applies. The first doctrine is strict compliance. The strict compliance doctrine is the traditional rule, and it says that any mistake in the execution of the will, regardless of how inconsequential that mistake is, results in the entire will being invalid. The entire will is invalid. So any execution of a will that does not strictly comply with the requirements that we just went over are presumed to be completely invalid. Now, while this is the traditional rule, it is not the most common. States have largely moved away from strict compliance, and courts have a little bit more leeway. Some jurisdictions have adopted a less restrictive doctrine called the substantial compliance doctrine. Substantial compliance doctrine. The substantial compliance doctrine allows the court to deem an executed will as valid, so long as there is clear and convincing evidence that the defective execution still accomplishes the purposes of the Wills Act formalities. So it requires the court to ask, what was the purpose of the legislature enacting that particular formality, and had those purposes still been met despite the failure to follow that formality? Most states have gone even further than the substantial compliance rule and have adopted the harmless error rule. The harmless error rule is also the rule that is adopted by the UPC. The harmless error rule allows for a will with defects in execution to be probated, so long as the court finds that there is clear and convincing evidence that the testator intended the document to be their will. So here the focus is on the testator's intent. Now, it's important to note that the UPC extends the harmless error rule to any will formalities that are missing, including formalities that are required for revocations or other modifications, topics we're going to go over in other videos. So far, we have gone over the basic will formalities for the execution of a will, and we've also talked about some doctrines that may give the court some leeway in determining the validity of a will. Now we're going to go back to some of the formalities that we talked about and discuss them in more detail. More specifically, we're going to look at the presence requirement in will execution. We previously said that one of the main differences between the English Wills Act and the UPC is that the English Wills Act requires the witnesses to sign in the presence of the testator. We said that the UPC has abandoned this requirement. For the states that still recognize the English Wills Act, or a version of it that they've adopted into their statutes, their courts are split on how to define what exactly presence means. There is a split in the courts in how they define the term presence. Some courts define presence as line of sight. And in doing that, they ask, if the testator were to actually look, would they be able to see the witness's sign? So the testator does not actually have to see the witnesses sign, but just needs to have been able to see them if they were to look. Other courts have adopted the conscious presence test, and we said that definition is used in the UPC. For the conscious presence rule, the testator, through sight, hearing, or just general consciousness of an event, comprehends that the witnesses are signing it. As one court says, the testator should be so near that they were conscious of where the witnesses were and what they were doing. So this presence requirement is part of the attestation requirement for a will execution. I want to talk in more detail about another one of the requirements we mentioned, and that is the signature requirement. More specifically, I want to talk about how should we define the signature. To determine that, let's first discuss what the purpose of the signature requirement is. The purpose of the signature requirement is to provide evidence of two things: finality and genuineness. So we're going to be asking what forms of signature evidence finality. And what we mean by that is what form of signature would distinguish a will from a draft or mere notes. So what we look for in determining this are issues that can arise due to the type of mark that it is, the location of the mark, or the timing of the mark. Let's start with the type of the mark. To qualify as a proper signature for a will, the signature can be the full name of the person. It can be a cross. It can be an abbreviation. It can be a nickname. It can also be a mark made by someone at the direction of the testator. As long as the testator intended to adopt the mark as their signature and intended to adopt the instrument as their will, then any mark could suffice as a signature. Now let's move on to discussing the location of the signature. Courts generally hold that the signature should be at the end of the document because it communicates finality. But some jurisdictions would allow the signature to just be so near to the end that it is a reasonable inference that the testator intended to authenticate the document. So near to the end that it's a reasonable inference that the testator intended to authenticate it. All right, now let's discuss the timing of the mark. The testator must make sure to sign the will after they have completed adding all of the relevant provisions. If the testator adds a provision after the will is signed, then the court will likely find that whatever was added in later is not going to be valid. Now, I'd like to discuss the timing of another mark, and that is the mark of the witness's signature. So remember here we have a difference between the Wills Act and the UPC. The Wills Act requires that at the time of the testator's signing or acknowledgement as part of one continuous transaction, the witnesses sign. Whereas the UPC only requires that the witnesses sign within a reasonable amount of time. Since we're on the topic of witnesses, I want to discuss one other requirement in regards to witnesses, and that has to do with interested witnesses. Most states require that witnesses in the will don't have an interest in the will. And if they do, if they are an interested witness, then the will is still valid, but the share that the interested witness was supposed to get under the will is affected. And the degree to which that's affected depends on the rule that the jurisdiction has adopted. We're going to go over the most popular of these rules. But first, let's talk about the reason for excluding interested witnesses as witnesses. And that is because it increases the likelihood that there is undue influence, duress, or fraud, concepts we're going to go over later on in this course. And while there are a few states that do allow interested witnesses, most of them do not. But even though most of the states do not allow interested witnesses, they differ in how they respond when an interested witness is a witness. Traditionally, being an interested witness would disqualify that person from taking under the will. So under these traditional purging statutes, they would purge or void the interest of the interested witness. And the court would treat them as if they predeceased the testator. A slim majority of states don't follow this traditional purging rule. Rather than purge the whole share, they only purge the excess benefits. This excess benefit is the difference between what that interested witness would have gotten in intestacy and what they got from the will. Some states might combine one of these two purging rules with an exception for supernumerary witnesses. Having supernumerary witnesses means having more than the two required witnesses. And if there are more than two witnesses, then the interested witness may still be able to take the devise in the will, as long as there are two disinterested witnesses. Thus far, we have been talking a lot about attested wills. But remember, the UPC also allows notarized wills, and that the notary signature can take the place of the two witness signatures. Aside from the notary will and the attested will, most states allow a third type of will, and that is called an holographic will. Holographic wills are handwritten wills, and because they are handwritten, they have different formalities than attested wills do. The primary formalities for a holographic will are that the will must be written by the testator's hand, and it must be signed by the testator. Now, courts disagree as to where the signature must be placed and how much the will needs to be in the testator's handwriting. So, where and how much? So, let's explore these two questions. This is an example of a pretend holographic will that there is no signature at the end, but the title of the document contains what can be argued as a signature. Now, courts are split as to whether or not this is sufficient. If you were to get a question like this on an exam, it would be important to spot the issue and identify the fact that courts would differ in how they rule. So, how much of a will must be in the testator's handwriting? Nowadays, it's not uncommon for people to get pre-printed will forms from the internet. And these forms have blank spaces so that the testator can handwrite their wishes into the document. Rules have evolved on whether or not to treat these wills as holographic wills. Your book says that there are 3 generations of rules that answer this question. And the first generation of rules required that the entire will had to be handwritten for it to be considered a holographic will. It had to be handwritten, it had to be signed, and it had to be dated. The second generation, 1969 UPC, required only that the material provisions of a will be in handwriting. The remaining part could be pre-printed. When applying this second generation rule, courts would strike the pre-printed parts and see if the handwritten parts alone made sense. And that's how they would be able to tell if the material provisions were handwritten. The third generation of rules is represented by the 1990 version of the UPC, and it requires that material portions be in handwriting, but it also allows for extrinsic evidence in order to interpret the handwritten provisions. So it allows for the handwritten parts to be taken into context with the pre-printed parts. So this completes Part A of Chapter 3, which covered the formalities required for a will to be valid. In the next video, we will review Part B of Chapter 3.